a lot of people file applications without doing a prior art search. And one of the basics of a patent application is that it has to be new. And sometimes, you know, with the vast amount of information that's out there, a lot of times people think it's new, but it's not. And sometimes people want to file things that are outside their area of expertise. They think they have a good idea to how to change things, and obviously it's more likely, the less familiar you are with the area, that something's going to blindside you and it's always been done, or it's not practical for some reason you're not aware of. But even if you're an expert in the field, how can you possibly know what everybody in the world is doing, especially behind closed doors, or what, you know, with all this information? So it's always helpful to do a search. And the most obvious reason is, if you don't do the search, you pay an attorney or you spend all this time drafting the application, paying the filing fees, and then the patent office does the search, because that's the first thing the examiner does, and they present you with information that's exactly what you've done. You've wasted all that time and money to do that. Sometimes people don't care. They want to scare their competitors off. They want that patent pending, and even if it's a long shot, they want to do it. And even if they get a patent that's questionable, again, they create some uncertainty with their competitors and so on, and they still want to do it. But the other advantage is, if you don't decide not to file it, it can help focus the application. We talked about before this technical document that describes how to make and use the invention and how the claims focus you on what you think the invention is. Well, the prior art can also help focus you, because if there's a whole area of what you thought was new that isn't new, you don't have to spend time talking about it in your application. You can focus on that aspect that's new. And so, and you can spend more time on it, and you can also spend some time differentiating yourself from this art that's close, and say why your invention is better than it, why it may not be anticipated, and just strengthen your case. You can't change that text after you file the application, so if you didn't know about the prior art, there's nothing to point to the examiner and say, see what I said in this application, this is why, I'm telling you why my invention is better than this prior art you just cited. If it's a surprise to you and they're presenting it to you, a lot of times you don't have anything in the specification talking about the differences, and the difference might be one sentence, where you could have pages and pages of why it's different and better, and when you have this better focus that's given to you by knowing what the prior art is. And sometimes they give you ideas of related ideas that can help you broaden the claims in terms of preventing design around. You say, okay, I see this related technology. Mine is patentable. It doesn't affect my patentability, but they might, starting from that point, I could see how they might do something to achieve the same thing I do by tweaking their invention to achieve the same thing. So I'm going to write my claims to prevent that. And so it can give you information and insight into writing the claims more powerfully too. And the other thing is, the claims are a negotiation with the patent office in terms of scope. If you have this unrealistic expectation of what your claim should be, you go back and forth with the patent office. You file your claims, they come back and say it's not patentable, these are art I cited, you tweak the claims, you go back to them, they come back to you, and there's delays between each of those written communications, there's attorney's fees with each of those communications, and so that adds up time and money, and if you start from a position which is much closer to the final position, you save all that. Why argue about something that's out there, they're probably going to find, and if they don't find, your licensee is going to find, and just get right to the point and find something more solid ground and as quickly as possible. So these days you really should do a prior art search. You can do the prior art search yourself to some extent with Google patents and so on, but a skilled patent search person can be very effective. Sometimes find things much more quickly, better than a novice, a layperson in the area. So I think it's maybe good to start with doing your own searches, but you may want to have a professional do it towards the end before you make the filing decision.